My name's Ollie Dent and I'm a partner in the Cyber and Data Risk team at Kennedy's. Class actions. Class actions are a very controversial style of litigation, and they've gained real traction in the US over the years. However, in the UK, claimants have never really been able to bring them. There are two different key types of class action. Firstly, there's opt-in, where every single claimant to the class physically signs up to the action. And secondly, there's a representative action, where you have one individual or a few individuals bringing a claim on behalf of a set of unknown individuals. Representative actions are therefore pretty controversial, as they can be extremely costly and lead to a lot of uncertainty. The case of Lloyd and Google tried to bring this sort of action in the UK. The case was brought by Mr. Richard Lloyd, who's a consumer rights activist. And what he was claiming was that for about 4 million iPhone users, Google had allegedly misused their personal data by using it in the Safari browser without their consent. If it had been successful, the claim would have been worth approximately £3 billion. But the court determined that the claimants didn't have enough evidence to demonstrate damage. What they were seeking was for damage for loss of control of data, without actually proving that they had suffered any loss, the mere loss of control of data being enough. However, the claim was dismissed by the court on the basis that the court said that the claimants would have to demonstrate material damage in order to satisfy the principles under the Data Protection Act 1998. A mere loss of control was therefore not enough. The court also said that for a representative action, there would need to be a calculation of damages on a common basis across the board. But due to the nature of the claim, it would have really had to have been dealt with on an individual basis. So ultimately, the court awarded in favour of Google, and the claim by Mr. Lloyd therefore failed. This is, of course, excellent news for data controllers and their insurers, but there are just two things to note. First of all, the claim was brought under the old Data Protection Act 1998, not the more recent GDPR of 2018. Therefore, that could theoretically be open to challenge, albeit the nature of the definition of damage is rather similar. Secondly, the court said that theoretically the claimants could, in the future, bring a claim on a two-stage basis. Therefore, a claim being brought on a representative action to determine liability, but then a series of individual claims down the line in order to claim compensation on that basis. However, that would be a much more complex and therefore costly routine for claimants to go down. So only time will tell in terms of how this will develop in the future.